Good morning, everyone. Can I welcome members, invited guests and the public, both here and watching on webcast, to today's meeting of the Housing Committee. This is my first meeting as its chair, following the changes to committee membership agreed by the Assembly last week, and members will also have been notified of an updated agenda front sheet. On behalf of the committee, I would like to thank the former chair, Assembly Member Tom Copley, and congratulate him on his new role as Deputy Mayor for Housing. The main item today is a discussion with invited guests on leasehold and service charges. Members of the public can follow the meeting on the webcast and on Twitter using hashtag Assembly Housing. Please may I remind members, guests and audience to turn their phones off or put them on silent. Have any apologies been received by the committee?
Yes, apologies have been received from Assembly Member Curtin.
Thank you. Item 2, declaration of interest. Can I ask members to note the list of officers on the report and ask if there are any other additional interest to declare? None? Andrew?
Yes. Because I've got a leasehold house, and we mentioned that a lot in there. We will be mentioning that. I thought I'd just mention it rather than the great formality of declaring an interest.
Sure. Yeah. Okay. Agenda item 3, list of actions. Can I ask members to note the outstanding and closed actions arising from previous meetings? Thank you. So that brings us to today's main item, a discussion with our invited guests on leasehold and service charges. Can I welcome our guests, Rebecca Catterbull, barrister at Grenfell Chambers, Sebastian O'Kelly, Director, Leasehold Knowledge Partnership, and Martin Boyd, Chair of Trustees, Leasehold Knowledge Partnership. So if I can start off by asking you, Sebastian, a couple of questions just to set the scene. So could you give us a background as to how leasehold has developed in England and why is it unique compared to most other countries?
Well, I guess leasehold in its current form is really something that cohered in the Victorian era when London hugely expanded and aristocratic landowners didn't want to sell the land on which they were building houses to the new Victorian middle classes, so they issued long leases. And a number of quite prominent Victorians got extremely upset by the fact that they couldn't actually buy their properties. The point was made by Lloyd George that, of course, you don't actually own the building on which is built on the land of somebody else. It's simply a rental property. So you put all the money into building a mansion, and after 100 years or whatever, it returns to the landowner. The novelist Wilkie Collins was very upset about this. Many of the points made in the sort of that you can read in the 1880s Hansard are exactly the same as the points we're making now. But sorry, to speed up. There are a number of sort of aristocratic owners of the big West London estates. We don't make too much of an issue of that. But the point is, one Duke of Westminster is enough. We're well on the way to creating 100 of them with leasehold in new blocks of flats spread along the Thames estuary, much to the disadvantage of homeowners who buy these properties.
So, yeah, I was just going to move on to ask you to outline the main issues that leaseholders face today, and does it align with the experience of leaseholders at Charter Quay? So, the main issues that leaseholders face today and your experiences at Charter Quay.
Well, I'll pass to Martin for Charter Quay, but the main experience of leasehold today is that we're hugely expanding leasehold and to the disadvantage of homeowners, and taxpayers are subsidising this with Help to Buy. So people are purchasing these properties. We've seen with the doubling ground rent scandal, they're often buying properties which are completely unsellable. There's no other jurisdiction in the world which is dumping people in such disadvantaged properties. I'll leave to Martin to talk about his direct experience of Charter Quay.
Yeah, my route into this was that I own a flat at a development along the river down in Kingston. And we, along with a number of other sites that had the same developer and the same managing agent, got together in 2008, 2009 and realised that we were all having exactly the same problems. We all felt we were being overcharged. We all felt we were being given very poor service. And each of the different sites took a different route to try and address their problems. We spent 5 years taking our landlord to court We recovered over £500,000 from them in the various court actions, and eventually we were able to force the sale of the site to the leaseholders in 2013, and the site has operated as a leaseholder controlled development since that point in time. I would not recommend to anyone that they go down the route of going to the tribunal. It is an appalling process. It is a totally one-sided cost regime. It doesn't matter how badly the landlord has behaved, the leaseholders have no right to their costs. Under all circumstances, the landlord has a right to his costs unless you can persuade the tribunal to limit them. But you can't stop them completely from passing on to the leaseholders.
I'm just astonished by that.
It's standard. You know, we were lucky, lot more lucky than other sites. An awful lot of sites just give up.
Yeah.
You know, it takes a huge amount of effort. We were very lucky. There were enough people that were willing to keep on fighting. We see, you know, all the time individuals trying to pick up an issue, and they give up because the system overwhelms them.
Mr. Kelly, you indicated that the leasehold's been with us a very, very long time. Why are we hearing so much more about the problems now?
Well, the main reason is that PLC house builders so overdid it with doubling ground rents. Introducing doubling ground rents every 10 years into leasehold houses and leasehold flats around London, incidentally, leasehold houses around the country, particularly in the northwest. This was an astonishing thing to do. It was a very bad idea dreamt up by a previous generation of executives in the PLC house builders. They created assets which are now completely unsellable. Mortgage lenders will not lend on these assets. So families who bought these properties are stuck with them. And you've got about, there's probably about 12,000 doubling ground rents properties and 100,000 with onerous ground rents, where the ground rents are above 0.1% of the sales value of the property. Now, mortgage lenders also won't lend on leasehold properties where the ground rent is above 0.1% of the value of the property. So you've got a whole load of people whose lives are on hold and are stuck. Another thing which has come up is the cladding crisis after the Grenfell tragedy. Now, we have numerous flats around the country which have either the ACM cladding, which was on Grenfell, or other forms of combustible cladding, which are now also unsellable. They are facing £1 million repair bills. A case in point is North Point in Bromley, in southeast London. This is a site of 57 flats. Its ground rent income collective ground rent income is only about £7,000 to the freeholder, so the freeholder's investment interest in this building is minimal, but the cladding remediation bill is £4 million. This is a staggering amount of money, and it's going to wipe those people out. So we're facing a considerable number of leaseholders in cladding sites who are going to be rendered homeless if our wretched leasehold sector service charge regime is used to sort this out.
So you listed quite a few issues there. Why do you think why do you think there hasn't, to this date, been more fundamental suggestions about reforming the system?
Well, you could say that just about every 10, 15 years there's a movement to reform leasehold, and the message still doesn't get through to our legislators. Stop reforming leasehold, just stop building more of it. Build common hold, which is the form of tenure in communal properties in every other jurisdiction in the world, including Scotland. It is simply absurd that we are selling long-term tenancies as flats. It doesn't matter whether this flat's at One Hyde Park and you paid 140 million quid for it. It is a tenancy, and if you don't keep the bills paid, particularly the ground rent, you could lose it through forfeiture to the freeholder. And the freeholder's ownership of a block of flats, the actual value of the freehold, as at North Point, which I said referenced earlier, could be minimal. It could be 1% of the collective value of the leases and the building. So with a minimal investment, this freeholder is the landlord and is hugely advantaged in law, as Martin was pointing out, and can forfeit properties for debt.
If those ground rents were capped or even scrapped by some action of the government, would that be a huge problem for the owners, the freeholders?
No, I don't think it would. And we're repeatedly informed that freehold owners of blocks of flats are pension funds. That used to be the case about 20 years ago, but since the sort of hyperinflation of UK residential properties, freehold ownership is now broadly, the investors in them are private equity, often based offshore, and they hide their beneficial ownership behind nominee directors, but they make core decisions. I mean, take the cladding sites. At some cladding sites, if there is no government money available to pay for this cladding, the freeholder has got responsibility to maintain this building. The only way he can maintain this building is to get the money out of the leaseholders. If the leaseholders cannot pay, and there'll be a considerable number who can't pay these multi-million-pound bills, he's going to have to take their flats off them. That's the reality of the leasehold system.
I mean, we could drill down on that, perhaps we will later on, about surely they've then, even if they did take property off them, they've probably got an unsellable property.
Well, that's for sure, yes.
Yeah. What's the industry's justification for the ground rents?
Well, you'd have to ask them, but
You've never asked them.
Right, well, there's a huge amount of lobbying going on to central government about owners of freeholds being the responsible long-term custodians of buildings, and only professional property managers could possibly manage a site. This is complete nonsense. I mean, I've never owned a leasehold property, thank goodness. But I have owned flats in other jurisdictions, and they work perfectly well. You know, in Italy and in France, everybody has a collective. You own a bit of the land, you own a bit of the corridor, a bit of the lift shaft, a bit of the roof, and you have to get on with your neighbours to maintain it. In this country, it is so confusing and deliberately obfuscated what exactly you own, and what is the responsibility of the landlord, and what is the responsibility of the leaseholder. And that works to the advantage of the commercial entities involved in this sector and to the disadvantage of consumers.
There's been a lot of controversy surrounding leasehold in the last few years. Do you think that leaseholders now are more aware and better informed than they were in the past?
Well, I would hope that they are better informed, because it's been the result. You know, I've been working to do this for the past 6 years, and I do hope that my labours haven't been in vain. But I think with multiple media exposure and parliamentary debates, yes, I think leaseholders are getting better informed.
And is there something we can do to prepare leaseholders a bit better than they have been?
I think there's considerable amount that the London authority could do on this. I mean, I think that it would be very good for London to urge developers to build, or insist that developers build with resident management companies, so that the leaseholders actually manage the sites. This cuts off a huge amount of the income streams in a building, because it will be the leaseholders management company which places the insurance contract, which won't be padded, which makes sure that the service charges are fair rather than loaded. It is very hit and miss whether a new site has a residence management company or not. It's often delayed as well, whether the residence management company control of it is actually turned over to the leaseholders. But it's something that you could insist on, that there is empowerment of the residents from the start. It would also be a good idea to get in copies of the leases from the various sites that you're approving.
Yeah. I mean, some of these questions I feel I could answer, to be honest, having my experience of buying a leasehold property. When I bought one 6 years ago, and I looked at a ridiculously low ground rent, and because of perhaps work by yourself, and your organisation. I looked at the ground rent and I thought, well, that's ridiculously low. Would I be happy paying quadruple that? And I was, so I went ahead with the deal. It's only since then that my neighbours, who probably weren't as cynical as I was about quoted costs at the time of sale, they're now getting quite upset about the way in which those ground rents have risen. I'm relaxed about it because I'm naturally cynical. But do you think house builders are entirely open about leasehold sale homes, particularly with first-time buyers, and the Help to Buy scheme?
Do I think they're open?
Do you think they're open enough?
No, I think they're quite self-evidently they haven't been open enough, which is why Taylor Wimpey has put aside £130 million to put right its doubling ground rent mis-selling, for example. So the PLC house builders acknowledge that things got completely out of control with loading the ground rents for new buyers, and it was very and help to buy has been used to purchase many of these properties. It was very depressing to discover that help to buy didn't apply to common hold properties, which do exist under English law. There's not many common hold properties in the country. There's only about 150 units with common hold around the whole of England and Wales, but it does exist. It's on the statute book, and help to buy wasn't available for common hold properties until we made a fuss about it. So, but in answer to your question, PLC house builders have played the angles of leasehold to the detriment of their customers and the detriment of us, the wider taxpayers who've subsidised the purchase of these flawed products.
Thank you.
If I just add to that, there was some, if you listen to the MHCLG Select Committee investigation of leasehold issues, they talked to a number of the PLC house builders, and one of them made very clear that they understood that verbal agreements that may have been made by their sales representatives did not constitute a contractual agreement.
Yes, I've heard that as well, because there was, I say to my neighbours, have you got that written down, that thing you mentioned about, about the promise? And of course, they never are written down.
Yeah.
That's very true. Thank you, Chair.
I mean, obviously, the whole issue of purchasing a property, whether leasehold or freehold, you need to go through the conveyancing process, and so you need to have a solicitor who's going to be able to advise you on whether things that the salesperson has said to you or whether what's in the documents is too onerous or is appropriate. In a lot of cases, the people who are selling a large site will offer the use of solicitors from a panel. Do you think those solicitors are sufficiently neutral or able to stand completely on the side of the purchaser? Do you think there's a risk that sometimes they are not independent enough? Do you think there should be some other arrangement, some other panel of... Because you obviously need someone who's going to have that expertise in that kind of conveyancing. And I'd like maybe to start with Sebastian, but happy for anyone else to comment as well.
I think it's been an appalling story, really. I mean, a solicitor recommended by a developer or an estate agent, for that matter, is in itself a reason to choose a different solicitor. And it's quite clear that in the doubling ground rent scandal, that the solicitors recommended by the developers were little more than the developers' stooge. They colluded in the sales process and landed their clients into these onerous and now unsellable properties and did a frankly disgraceful job in the conveyancing process. There is quite a lot of litigation going on against these conveyancers. I'm aware of 17 cases where there have been settlements. I think there'll be others that follow that. I would urge you to take a look at the Conveyancing Association, which has done some good work in looking at the conveyancing of leasehold properties, the bogus charges that are loaded on sales transactions of leasehold properties. A leasehold property is a good deal more complicated to the conveyancing on than, say, a 5-bedroom house in Guildford. It can be full of complicated and onerous terms that require a good deal of skill to look at. And the Conveyancing Association has done some pretty hard-hitting stuff on this. But regarding the recommendation of solicitors, we've had this time and again in other sort of property downturns, where generally speaking, if a developer is recommending a particular solicitor, it in itself is a reason to go elsewhere. It's too partial.
So we've moved really from saying that they're not just not independent, but some people are now litigating because they've effectively really been acting pretty much for the other party.
There is a particular problem with help to buy because the timescales in the help to buy process are very tight. So one of the things that's reported on a very regular basis is that the purchaser doesn't actually see the documents until the very end, so they have 48 hours to review everything, that seems to have encouraged a number of developers to say, well, if you don't use our preferred solicitor who knows the process, you may not be able to complete in the required timescales. And first-time purchasers believe that they're being told the truth.
Is that 48-hour turnaround period legal, given that I thought there was meant to be something like a 2-week cooling off period and a proper ability for people to...
As I understand it, the timescales are set by Homes England.
Are they? Okay, but I thought there was an overriding piece of legislation that introduced the capacity for people to examine the small print. I can't remember what the legislation is called.
May well be, but it doesn't seem to apply.
It doesn't apply to Homes England. Okay, so if it's a quasi-autonomous non-governmental organisation such as Homes England, a primary piece of legislation doesn't apply? That seems a bit odd to me. 48 hours.
It might be worth asking Homes England why there are some very tight timescales.
That might well be something that comes out of our discussions today. Okay, I'm quite surprised by that. Obviously, also, where you've got the situation with freeholders, once people have purchased their leasehold, they may also not have noticed that in the small print it says something about if you want to change the windows, the doors, that you've then got to pay another fee to get some sort of permission from the freeholder to make changes that you think are quite essential, and that in many cases also applies to councils as well as to private freeholders. In your view, would you say that permission fees are necessary? And also in some cases where people have asked to put things in, they've also then been told they've got to pay an amount that goes towards the fact that the property is going to be worth more at that point as well. I've had some examples where people have come and said, not only have I got to pay for the door, but I've also got to pay for the increase in value that the property will now exhibit once I've improved it. Do you think this is fair at all in any size, shape or form?
I think they've been sort of rather, these permission fees have been monetised ruthlessly by the larger freehold owning organisations. So I think it costs £80 to keep a cat, for example. One of the larger freehold companies charges that. Your broader point of should the freeholder be involved in granting permission? Well, obviously, yes. If you're going to redo your bathroom in a block of flats, then there needs to be some sort of supervision on that it doesn't leak. How much it should cost is for that sort of consent is where it becomes controversial. None of these fees are sort of are set down really in any sort of quantifiable source. So it's really made up by the freeholder as he goes along, and unless they're challenged in tribunal, that fee stands. So some conservatories might cost, £150 to put on the end of your leasehold house, but we've come across others where it might cost £5,000. Now, in central London, quite a game is played with retrospective consent, where I'm aware of one woman selling her family flat, and the freeholder wanted £120,000 because the bathroom had been changed, I think 35 years before, by the previous owner, and he wasn't going to sign off on the sale until this money had been tracked. This is sort of just extortion. So these consent fees are abused on a huge scale in this leasehold sector because of the unbalanced relationship.
Well,
that
that's
you
quite
described.
astonishing. Perhaps they should have put back the original bath and then not paid the large
Oh,
amount
but
of
then you'd
money.
have to have consent to put back the original bath, so you might find...
Oh, they have to pay 240 to put the original. Do you think the government can do something in terms of legislation to ensure that freeholders are not allowed to charge these excessive or unreasonable permission fees? I completely take your point. I do think it is, if someone that has the freehold, I think it's quite good to have the leaseholders to come and say, this is what we're planning to do, is that okay? And then everyone knows what's happening, particularly obviously because there have been instances where leaseholders have done things and have, for example, breached fire compartmentalisation, which is, which we don't want at all. Do you think the government can do something to stop excessive or unreasonable levels of charges?
At the moment, one of the many reviews that are underway is looking at the charges that are applied, and there's a general acceptance that the fees need to be both genuinely reasonable and also challengeable. The problem you have with many of these consent fees is it will cost you a huge amount more to challenge them in the courts or the tribunal than you could ever hope to recover. And lots of landlords have realised that on that basis they can gradually sort of milk the system more and more.
So someone wants to charge you £5,000 to put on the conservatory, and then it would cost you £10,000 or £15,000 to challenge the fee that they've said they're going to charge. So then you could be potentially out of pocket by £20,000 instead of the £5,000. So that deters people from legislating. Is that?
You could be, but Rebecca can explain much better than I can that there is an element of balance. There is some potential to recover your legal costs depending on which jurisdiction that you take the matter forward in.
Did you want to come in at that point, Rebecca?
Yes, I mean, the Common Hold and Leasehold Reform Act, Schedule 11, made provision for challenge of these administration charges, which would include some of these charges for consent. Now, there are two ways. One, if there's a variable administration charge in the lease, so for example, say they say the landlord is entitled to make a charge for any consent for alterations, and it is not couched in terms that it is in accordance with a formula, then that could be challenged. And the challenge would be whether it's reasonable or not, and very similar to the challenging mechanism for service charges. If it is a non-variable service charge, i.e. one which is specified, so it's a fixed amount, so every time you ask for permission to change your bathroom, you have to pay £250, that would be a fixed amount, or if it's done in accordance with a formula, that too falls within a definition of non-variable service charge. Your remedy, or the tenant's remedy in those circumstances, is to apply to the tribunal and ask for it to be varied on the basis that it's unreasonable. Because the tribunal has a discussion about whether to vary the lease or not. Now, the big difficulty with this is exactly what Martin identified, which is the costs of the leaseholder going to the tribunal to do that, because even though you have a system which is divides to be effectively a no-cost regime, albeit there are some powers for the tribunal to make cost orders, that's all very well if you are a leaseholder and you're against the landlord who's a litigant in person as well. It doesn't assist if the landlord employs or instructs solicitors and counsel to attend. We all know that leasehold law is incredibly complex, and the other difficulty is even if you walk away and nobody is bearing any costs, you bear your own costs, the landlord, depending on what the terms of the lease say, but could actually seek those costs through the service charges later on.
Sit back on through the service charges.
Yeah.
So that's quite tricky, because even if you're successful, you can still end up taking on the costs of the other party, as it were.
Yes,
Because,
I mean,
because
there is
quite commonly leases will make that as a point.
Yes, I mean, you can have lots of arguments
Yeah.
about looking at the lease and arguing whether the landlord is entitled to seek legal costs and the nature of legal costs, and it will all depend on a case-by-case basis in looking at each of these leases. But there is an ability for the tenant to apply for an order from the tribunal or the court, depending on where the litigation has taken place, to ask for an order that the landlord cannot recover those legal costs through the service charges against that particular applicant, so or specified people, so the person who has applied for what is called a Section 20C order. But that in itself doesn't always work. And you're still dependent on the tribunal making that decision, and it may not apply to all of the leaseholders.
No, because of course that's one of the strange things, isn't it? Because quite commonly the costs of the landlord will be split up across all of the leaseholders. You could potentially have one person who's got into the litigation, and then the landlord could seek to recover their costs of the litigation with that one individual against 20 leaseholders. So you could end up paying the cost of the landlord's litigation with your neighbour, or share it anyway.
Yes.
This happened at Chelsea Harbour. Very upset they were about it too.
Yes.
Each of the non-litigants had an additional £1,000 added to their service charge.
Yes, which is slightly galling if you weren't involved in the actual litigation in the first place, because of course that's also something that the freeholder is free to do. Sometimes in terms of the lease. So I mean, we've mentioned the idea that you could be charged quite a lot for putting in a new bathroom. So it applies not just to things like windows, which I mentioned, or doors, but also to some of the fixtures and fittings in the property. Almost anything can.
Well, potentially, it all depends on the lease itself.
Right.
That's what I'm saying. So you have your starting point is what is a contractual arrangement between the landlord and tenant. So you look at the terms of the lease, and it will be within that where you will find whether you're liable or not to pay these amounts of money. So that's what I'm saying. Not all leases are exactly the same. They're all drafted in a different way, depending on the kind of development and type of flat and who's drafted them, what the landlord wanted.
Now we've also got the sort of go nuclear option, which the landlord is able to use, which I think goes back to an even earlier period than the Victorian time of the concept of forfeiture, which I think is sort of a very ancient
yes, I mean,
concept.
if you really want to think about leasehold law, you need to really go back to William the Conqueror. But yes, I mean, forfeiture is a draconian measure. I mean, it's. If we forget about the problems of modern day, but part of it is to do with where you're dealing with payment of money, that there needs to be an easy remedy or some kind of enforcement procedure or some protection there for the person who's due to be paid that money. And generally, if you look at any statutory scheme that has come in to play over the last 60, 70 years, where it's dealing with payment of rent, despite giving security of tenure to the tenant and making it more difficult for the landlord to recover possession when it comes to rent and non-payment of rent, Parliament has generally allowed the landlord to have a much easier way of being able to recover possession. So, I mean, you can find it in Agricultural Holdings Act, you can find it in the residential sphere in terms of, short-hold tenancies. The big problem with forfeiture is that if the landlord is successful in forfeiting the lease, that's it. Your leaseholder is not going to be able to get back the money they paid when they bought the flat in the first place.
No, I think that's one of the...
And it's a big woodfall.
It's one of the which is why I said it's a sort of go nuclear kind of thing, because if the landlord goes down the route of trying to forfeit the lease, then that's it, it's gone. And even if you've been purchasing it on a mortgage and you've spent thousands and thousands of pounds, it's gone, and you will have forfeited everything that you've paid in. So you're no longer in ownership of
yes, you don't
something,
get any,
and you don't get any
payment.
compensation or anything.
No.
So it's just literally gone. So in your experience, how frequently do freeholders try to impose forfeiture on their lessees. And how often are they successful?
Well, there are two different things.
Yeah.
One is that landlords will definitely go down that forfeiture route, but it is a means of being able to get what they want, because ultimately, at the end of the day, it is very rare in residential leases for the lease to actually end up being forfeited, because the tenant can apply for relief from forfeiture, pay the arrears. When you've got a mortgage, invariably what would happen is that the mortgage company will pay and then add it onto your mortgage.
Could I just comment
Yes,
on
of
this? The threat of forfeiture is absolutely routine. It's the way that landlords get money that is owed. And I'm about 3 times a week I'm being contacted by leaseholders with various caught up in the sort of forfeiture game. They've missed ground rent for one reason or another. They say that the demand hasn't been sent. A debt collecting solicitor then contacts them on behalf of the landlord. A £250 debt quickly becomes a £1,000 debt with the legal fees, then 2,000, 2,500. Up it goes on a very aggressively escalating scale. The reason is these debt collectors aren't actually employed by the freeholder. Their remuneration comes from recovering the debt. So they are sort of incentivized, if you like, to pursue these debts aggressively. Now, I'll give you an example of a forfeiture that happened recently. We think that there was about 80, when we last looked at this, we thought there was about 82 forfeitures a year actually granted, and about 150 which get into the court system. But as I say, forfeiture is routinely threatened. Now, the case that I was going to reference is a Chinese family who owned a flat in Chinese-Canadian family who had a flat in Camden. And the 24-year-old daughter who was occupying it went back to Canada but was disputing a sort of water leak, and her brother, a student, moved in younger than her, and didn't forward any of the correspondence, didn't engage with the landlord whatsoever, and there was a knock on the door and the bailiff turned up to say, "You've got to get out, this flat has been forfeited." And now relief of forfeiture has been sought, but it's going to cost this family, I think the debt was something like £2,500, but it's going to cost the family about £30,000 to get relief of forfeiture. So it does happen, but a relief of forfeiture process does exist, but it comes at a very high price indeed.
Wow, that sort of takes it to a whole new level, doesn't it? And of course, as you were saying, quite often the mortgage companies, who effectively would then have a mortgage over nothing. If the property is forfeited, the mortgage would continue, but if it's been forfeited, then the security of the property is no longer there. So they would be quite incentivised themselves to presumably step in.
Yes, this is how most forfeitures actually are avoided, because the mortgage company does step in to protect the loan. Otherwise, the loan goes as well. The whole asset is forfeited. But another example I'll give is in a maisonette in North London, where a young man who owned a £600,000 maisonette with cash started changing the bathroom and annoyed the neighbour downstairs, who happened to be a freeholder. We're talking about a sort of Victorian maisonette here, and there's no serious commercial involvement in this, but the lady downstairs got so cross that she went to court. He didn't engage with the process whatsoever. There was a debt of, again, about £3,000, something like that. He paid no attention to the court at all, and she went for forfeiture, and she obtained it. And, of course, there was no mortgage company to intervene on that, so this lady was inconvenienced, but she now has a £600,000 asset that is hers.
Ouch, I would say. So that's quite a difficult situation for lessees, as it sounds as though it's being used as a weapon. It's being wielded very much as a weapon to direct lessees towards something that the freeholder demands.
Also, where it's bad enough in the private sector, but the social sector are quite active in using forfeiture powers as well. And we've had a number of cases of right to buy tenants who have either faced huge costs or in some instances have lost their homes.
So right to buy tenants of councils who've also had the threat of forfeiture, or indeed the council has gone through.
Yeah.
So it's the threat or indeed the actual. So I presume you haven't had any examples of this yet, but earlier on you were talking about Grenfell, and obviously there are now some examples of leaseholders living in blocks where the council is undertaking what might be extremely expensive works, and they might be faced with a very large bill.
Yeah, the largest we've seen so far is demand for £146,000.
Right.
And eventually the council decided that it would allow that £146,000 to be repaid over a 6-year period rather than their normal 5-year period. But that was only something that was available to tenants who lived in their flats. If there were buy-to-let investor tenants, they had to pay the £146,000 when it was due.
Okay. So that's a pretty big impact on leaseholders of something that, although we might say buyer beware, caveat emptor, it would have been quite hard when you purchased something maybe some years ago under the right to buy to know that something like this was going to develop. So there are potentially some very large bills coming down the pipe towards some leaseholders.
And that's what we have with cladding in, times N now. And as the cladding issue rolls out beyond the ACM problem, it is very clear that a huge number of leaseholders have now got homes which are valued at nothing until they're remediated, and they have no means to borrow the money, therefore, to pay for the remediation. And they're expecting bills which are very often going to be more than £20,000 per flat.
Now, I mean, I sit on the fire committee as well, and we've had some discussions about the issue of sprinklers over the years in the Assembly, particularly post Larkanel House in 2009. Do you think councils should be seeking to fit sprinklers into leaseholders' flats? And there's one example of one council that was then using its housing revenue account to fund an approach to the first tier tribunal, which has now actually just been rejected at tribunal, but they were funding their solicitors through the HRA.
Yep.
I
gave evidence before you on that committee as well, and I think I made very clear we are not specialists in the technical aspects of buildings. We know bits about leasehold, but it's very clear the issue of sprinklers is one that's going to become more and more relevant. Retrofitting is difficult. We didn't have any involvement in that case that you were talking about. It's the first time I've read a decision and thought that everyone got it wrong. I thought the leaseholders got it wrong, I thought the landlord got it wrong, and I thought the tribunal got it wrong.
Well, that's pretty comprehensive then. Anyway, thank you very much. Thank you, Chair.
Thank you. So moving on to the next set of questions, which are on the role of the Mayor of London. And can I hand over to you, Andrew?
Thank you. Mr. Kelly, Mr. O'Kelly, sorry. What do you think of the Mayor's guide for leaseholders, and have you heard anyone in your network that it has been of use to?
Well, I think it was very encouraging that the Mayor was going to intervene on this. The preamble to it was he was setting this up because the government-funded organisation, the Leasehold Advisory Service, was not fit for purpose. Now, I think what prompted that criticism of this organisation was the Communities Select Committee report, which took evidence from a considerable number of leaseholders who expressed strong dissatisfaction with the Leasehold Advisory Service, referencing it as appalling or useless. It has also been publicly admonished by former Housing Minister Gavin Barwell and told that it had to be on the side of leaseholders. There has been a perception, and indeed evidence, that the Leasehold Advisory Service has assisted the sort of freehold owning commercialisers in the sector. It organised a lot of sort of commercial conferences and so forth, where every freeholder and professional who seeks business from them would turn out. So there is a perception amongst leaseholders that this government-funded body is not serving them, but serving the freeholders who monetise their homes. This explains why other organisations like us are addressing leasehold. So in answer to your first point, it is very welcome indeed that the London Mayor is producing advice for leaseholders, and I think that it would be extremely well received by leaseholders generally that there is another source of advice.
Do you know of anybody who's actually used it?
I don't.
You don't. Do you?
I have.
Oh, you have? Right.
I used them for many years. I think the first time I used the Leasehold Advisory Service was in 2003, when we were trying to look at what our options were. And then I also had a commercial solicitor came in who set out a different set of options, and we followed that route. And then when we were going through our litigation in court, I'm afraid I got to the point of using the Leasehold Advisory Service to help me understand what the landlord's arguments might be. And if the Leasehold Advisory Service didn't understand something or weren't aware that it was a particular point that we might use, then I used it. And if the Leasehold Advisory Service told me they knew all about it, then I knew that our landlord would also know all about it.
Have you heard of anybody using the Mayor's Guide?
Oh, the Mayor's Guide. The Mayor's Guide, yeah, we have heard some people. And to give you a bit of a background, I mean, this is... the Housing Committee has been looking at leasehold on and off over a long period of time, and you produced an excellent report in 2012 called Highly Charged, where you had understood many of the issues that are now under review. But if you look at the executive report at the front of that, it makes very clear that at the time the GLA understood there was no interest from central government in reforming leasehold law. Now, your only problem was then, as you have now, and it reflects onto what you've done with this Leaseholder's Guide, is unfortunately the GLA has absolutely no understanding of how big the leasehold sector is. You understand, unfortunately, less now than you did in 2012. So we helped the officials who were producing the report in 2012, and the one thing we couldn't give them then was the numbers. There were no numbers about how big this sector is. So in that report, they'd talked in 2012 about there being about 500,000 leasehold properties. In the Mayor's Guide in 2018, he says there are 500,000 leaseholders, over 500,000 leaseholders. That is so wrong, it is ridiculous. We helped the government produce their first set of official numbers in 2014, and we produced a big report, and I put the London numbers in there, and they weren't estimates, they're real numbers, but we have, including the social sector rented flats, 1.5 million properties in London. That excludes leasehold houses. We didn't look at leasehold houses at the time, so if you can guess, from 2011 to now, we know that almost everything that's been built in the capital is leasehold property because they're all flats. Okay, and so that 1.5 million properties could very easily now be 1.8 million properties. So if the whole of the housing strategy is based on the assumption we've got about 500,000 properties, and actually it's 1.8.
So that figure you saw was in what document? 500,000.
Right, the 2011 is a report that we produced in 2014.
Yeah, but you said the Mayor's reference.
So the Mayor's reference is the 2018 housing strategy document.
And says that
it's on page 14, and it says there are over 500,000 leaseholders in London. Well, obviously it meant to see, let's say, leasehold properties, because obviously, more than one person is likely to live in a leasehold property. But even so, at $500,000, it is a huge underestimate. There are at least 1.2, 1.3 million flats in the private sector, plus all of the leasehold houses, plus all of the social housing stock.
I think that warrants some action on our behalf to chase that figure up and see.
We've been
such
suggesting to the
Sorry,
GLA they might
Chair,
like
here.
to talk to us about numbers for years.
Yeah.
Just told 1.5 million, you just said in the private sector. Yeah, I thought you were saying earlier the social sector.
No. This is so the
It's
figures I have.
leaseholders leasing X right to buy flats in the social sector.
No, well, they could be anything, and there is the difficulty in the social sector. So the figures were it was 1.1 million private flats in 2011, and there were 536,000 flats in the social sector. Now those flats will either be leasehold or they will have no title at all, because it used to be historically in council block, the council would just own the freehold of the block, and the only time a lease would be issued would be on a right to buy flat.
Yeah.
So those flats just didn't exist at the land registry. But clearly they are flats, they are there, so they were just never appearing on any records. If it's a RSL that owns the property, that is much more likely to have a leasehold title. So it's only the historic council stock that might not be leasehold.
Well, that's fascinating, and it's something we'll probably will chase up and investigate. Do you think it confuses people to have a London-specific guide with the Mayor's Guide, or?
No, I think it was very disappointing. The guide, we were quite optimistic when the guide started. It started from a position in February 2019 where the Mayor had said the existing formal government advice system is not fit for purpose. It then seems to have decided that leasehold law was a bit complicated, and having produced some initial front-end guides, which are sort of introductory level, shall we say, it then ends up just pointing back to the government's formal system. So you end up asking, what was the point of it? It could have been much stronger, I think, in alerting people to the issues of developer recommended solicitors, the sort of problems you get with shorter leases, the sort of problems that you can get into, things like property alterations. I mean, people just do not understand what leasehold property can be. Particularly leasehold house owners, by the way, because you are as stuck in having to ask permission to change the boiler in a leasehold house as someone is in a leasehold flat.
Is there anything the Mayor of London, or indeed London boroughs, can do prior to any legislative reform to assist existing leaseholders, or to perhaps in restricting the sale of new leaseholds? Is there anything they can do?
I think that the Mayor could certainly play a much stronger part in trying to control some of the lease terms that exist within the shared ownership part of the market. We see some quite challenging terms in some of those leases. We still see social landlords trying to sell properties brand new on 125-year leases, and that is just disgraceful. It should never be allowed to happen. So the Mayor could certainly sort of intervene in that. He could help encourage a greater level of transparency. I mean, quite often when you're buying a new build property, actually getting to see the lease before you've signed a contract to say you're going to buy is impossible.
48-hour business, yeah.
And you've also then within Help to Buy, you've got your 48-hour issue as well.
So are you recommending perhaps that the Mayor have a much more granular view of developments he's involved in?
Yeah. I mean, the moment the Law Commission is looking at the reform of common hold legislation, since 2012, the Assembly has been saying it supports a move to common hold, and the Mayor said in his housing strategy that he thinks London should be trying to move to a more sustainable form of tenure, I think was his words. It's going to be a year or two before common hold moves forward, but yeah, the Mayor has a key role to play in helping push forward a common hold system as an alternative for leasehold for new build properties.
But you're saying he has to wait. Why does he have to wait? You were saying a few years before.
Because he needs the legislation to be reformed before it's really worth pushing on that. But I mean, it's planning takes a long time, so there's no reason why he can't be putting in there that that London will be looking to move towards common hold as quickly as it can.
I think in the meantime, it would be very advantageous if he pressed for evidence of the leases on these huge sites that are being, receiving planning permission in London. Why don't we know the legal contracts involved in the sale of these assets to consumers? And I would have thought, prior to common hold, pushing for residence management companies as a default position in new developments. It is surely desirable that the people with the greatest financial stake in a block of flats control its management. So why aren't all sites in London built with residence management companies? It's very hit and miss whether they have one or not. It's just at the discretion of the developer.
Do you think it's going to be possible for the private market tenure to be a condition of planning permission in the same way that Section 106 agreements set out for affordable tenures? Do you think?
Well, I like that very much.
There are a number of councils up in the northwest that have, and one of the London councils that began to pass motions to very much suggest that route as the way forward.
Thank you.
That's a bit of a bang.
Yeah, I just wanted to get a bit more clarification on that. So the idea that you can put lease conditions into planning permissions is really, really interesting. Obviously, you've implied that the Mayor can use his funding conditions, particularly where he's funding shared ownership flats, to put those kinds of conditions on. Can I ask Rebecca, as you are the lawyer in the room particularly, do you think that's possible? And in which case other lease conditions could be included? For example, I mean, other issues we take up as a housing committee are things like short-term lettings, for example. You could make that a condition.
I mean, I don't do planning, but the fundamental problem we have to start is there is a private arrangement there between two private parties, whether it's the developer, the freeholder, and the tenant. I agree, Parliament has intervened previously between contractual arrangements and private contractual arrangements. I'd say that it just really depends exactly what you are proposing would be incorporated as a lease term. And the problem with, common hold, in some sense, it's a brilliant idea, but the big issue in London is that you're not just dealing with residential developments, you will be dealing with mixed-use developments. So you're having to look at not just residential leaseholds, but also commercial lessees as well. And sometimes that commercial asset has to be included to make the whole project viable. So you're going to have to look at, and this, I think, part of the reason why the Law Commission is going to be looking at it this year, I think coming out with their report later on in the year, but is having to get in the spring, is looking at this issue about mixed use. It's not kind of just, it's not, the legislation at the moment on common hold is really looking at kind of modest blocks and residential blocks rather than actually looking at it from a mixed use perspective.
So the government's discussed in its recently with the new, what are they called, first homes, that those would be secured as Section 106 agreements. And it seems to me like those are going to come with lease conditions that say you cannot sell it on for more than the discounted market rate that was first bought for or some proportion. So it seems like that is something government is confident it could do. And the question is, how far can we go?
Yeah, I mean, there are the Welsh Assembly has just got a consultation that is opened about what to do with some of the permission fees, and in particular the permission fees that arise out of 106 agreements, where almost all new housing developments are deemed to be private estates, and the people, whether they're leaseholders or freeholders, end up having to pay an estate charge to maintain their roads and the grass verges and the lighting, etc., in addition to their paying their ordinary rates. And what the Welsh Assembly has understood that is causing a new set of problems. It's not as obviously a bigger an issue for London because we're not building that many houses anymore in the capital, but it certainly is something that they've decided that needs to be addressed, and they have proposed things like the formal adoption of all open areas on any new development after a period of 5 years.
Nice.
And I know because, you know, in the capital what we get is we get blocks of flats developed, and you know, the local authority will make the development pay for their public spaces. So on our development we are responsible for part of the Thames walkway. And when everyone moved in, I don't think they had any idea that that was part of their cost. But it's in the 106 agreement, so the local authority says, well, that's tough. You get the privilege of living by the river, so you can pay to maintain it.
That's really interesting. Did you want to add anything, Sebastian?
Well, it's a kind of there is a discretionary thing here. I think it should be. New sites should be self-governing unless there's an overwhelming reason why they shouldn't be. You know, this is really what would be resisted, I think, by the sector. Can I just point out that, you know, Martin Boyd, as well as being chair of the Leasehold Knowledge Partnership, is chair of Charter Quay. Charter Quay is an extremely complicated mixed-use site. It's worth over £300 million. It's got the Rose Theatre, Carluccio, various restaurants, and Thames Riverside, as he was pointing out. It's got a huge amount of legislative complications in there in this site, yet it is self-managing. So it is a nonsense to think that these commercial, you know, a degree of commercial property involved in the site means that leaseholders can't control it. If they are the overwhelming financial stakeholders in a site, of course they should manage it. Certainly not the person who owns 1% of the site and happens to be based in the Cayman Islands. Why on earth should they have all the power over the site and appoint their mates to manage it and their chums to place the insurance contract and so forth? This is the culture which needs to be eroded, and which the mayor could do. If the site doesn't have a residence management company, why on earth not? If a site comes up with a 125-year lease, which is a very short one, and buyers at the site aren't seeing this up front, why not? These should be the questions that I think could be just a soft power pushing rather than anything too draconian.
Okay, thank you.
So moving on to looking at remedies for existing leaseholders, can I bring you in, Member Devonish?
Thank you, Chair. Actually, I'm going back to the point that's just raised with Martin this time, please. How were the residents of Charter Quay able to resolve the issues they would experience? And perhaps you should start by just setting out what they were experiencing.
Yeah, we were. We all felt we were being overcharged for the services being provided on the site. The site was being very badly maintained. The crunch point came for us, I think, in the end of 2007. We received the estimate from the property manager for next year's service charge, and then I think the week before Christmas, we all got a note saying, very sorry, we forgot to mention we have a major works plan for the next 10 years, and here it is. and you're going to have to pay this in addition to the previous charges we've told you. And I think everyone looked at it and felt that the costs were very generous, to say the least. I mean, it was obvious from looking at the plan that whoever produced it hadn't taken into consideration the structure of particular blocks. So we have one block that has 60% commercial unit, but this 10-year plan proposed that the commercial element on that part of the development would pay nothing, and that the 40% of residential would pay 100% of all the costs. So their major works bill was going to be very, very large. We desperately all got together, and the first thing we tried to do was form a residents' association. And that is very, very hard. There are a ridiculously large number of obstacles that get put in the way of letting leaseholders organise. And we have been pushing the government since 2010 to say they should do more to encourage residents' group, because you can fairly obviously have a more professional and business-like relationship with an organised residents' group rather than having to deal with every individual leaseholder on their own. But for the landlord, the disadvantage of an organised residents' group is that they're organised, and therefore they are more likely to challenge you, which is what we ended up doing.
Thank you. But how were you able to resolve the issues then? Just by working as a team, you're basically saying?
Yeah, we worked as a team. We were very lucky. We had some people on the site who were very beneficial to the various legal cases that we tried to bring. And our route was to initially have the landlord's managing agent replaced. Unfortunately, that bit of legislation doesn't seem to work very well anymore, so we sort of partly shut the door behind us with that one. We then took a number of service charge cases to recover the money that we'd been overcharged, and that doesn't work quite as well as it used to. And then we went down a compulsory acquisition route to buy the site, and as I understand, since we did it, there is no large site in the country that's ever been able to do it since.
And can I just ask how many residents were very, very active in this approach? Because clearly, unless you have a bunch of very well qualified, very, very articulate middle class residents, it's not going to work, is it?
Well, I would dispute the fact that they need to be middle class.
Okay.
I mean, that's
everybody's middle class in London now.
Everyone,
maybe that's the wrong word. I'm being told off by my colleagues.
If we're going to assert that everyone in London is middle class, then I mean there is. You are right. You do need some educated people who can understand things like accounts or understand the way that buildings work. That is much more difficult to do in social sector blocks, because there are a lot less leaseholders in social sector blocks, but we do know some of them that have tried. It is hard. I think we probably had about 10 to 12 people who were actively working on the project.
Thank you, very helpful. And on to Rebecca, please. For leaseholders who are currently stuck with onerous lease terms, or whose freeholders are charging an excessive service charge, what remedies are available to them right now?
Well, there are various things that can be done. But this is part of the problem, because there are lots of different routes which not all leaseholders be aware. I mean, service charges, if you are you're being charged excessive charges, then you can challenge those charges through the tribunal system. But we go back to that issue that we raised earlier on, which is the cost issue. So the amount of money it takes to get there. In relation to onerous terms on existing leases, one, it's difficult to define what an onerous term is. There isn't any statutory definition. You can look at it within the unfair terms legislation, the Consumer Act in 2015, which relates to new leases. The older leases, so prior to 2015, you will be dealing with the unfair contract terms regulations. The big issue, with that is whether it's an unfair term if you considered that you were given legal advice when you entered into the lease, or that you had the benefit of legal advice even though you weren't possibly being advised specifically on that clause. So the question is there, actually is there any significant imbalance between you and the landlord? So whether that would actually constitute an unfair term. There was one Court of Appeal case a couple of years ago which suggested that there wouldn't be that significant imbalance. So whether you'd be able to challenge it on unfair terms is a different question. And actually there really isn't any other cases out there. One other possibility, particularly when you're coming to onerous ground rents, which again, it's generally the view that if they're 0.1% of the value of the property, then they're going to be onerous. But there isn't actually a definition of what an onerous ground rent is. But if they exceed a certain amount, so in London, if it is over £1,000 a year, or outside London over £250 a year, you're not going to have just a long lease. You will have an assured tenancy. And the problem with that is that the landlord could seek possession and rent arrears under Ground 8, which is a mandatory possession order. And you don't even have the opportunity, as you would with seeking, with forfeiture, being able to seek relief from forfeiture. Now, it may be that the mortgage company steps in again at that point. But there is a big problem with some of these leases with these onerous ground rents, that once they reach a certain level, they end up falling within a assured tenancy regime. Now, what happens to those leaseholders in that position is that sometimes they're looking to go back to their conveyancing solicitors and think, well, actually, can I sue in negligence? And there, I think Sebastian mentioned this earlier, there are a number of cases out there where people have tried to sue their solicitors. A lot of them will be settled. There isn't one that's actually reached the courts yet. Most of the solicitors' insurance will end up coughing up, so it's unlikely you're going to see any anytime soon. And there's an additional problem, and that is that some of these leases are quite old, so you may even have a statute of limitations point, so you're statute barred from actually being able to sue in negligence. There are rather complicated arguments about whether you could say when you had constructive notice of that onerous term in the lease, but generally it's going to be quite difficult for those leaseholders where you've entered into the lease a long time ago.
Thank you. And for the other panel members, what's not in law at the moment, what other remedies could be provided in future for leaseholders currently stuck with onerous lease terms, do you think? Sebastian? Sorry.
Well, actually, they've really started taking steps forward on this, and there isn't actually anything in legislation yet, but the government's already indicated about what they're planning on doing with houses and ground rents and leasehold houses subject to certain exceptions. It could be that you could have within the 2015 Act the indicative clauses which would be considered unfair. And so you could make provision in that respect.
Anything else from the other panels?
Well, the Competition and Markets Authority is looking specifically at this, at the ground rent issue, and whether these properties were missold, and we'll get that report, I think, in March. Right. So spring. Okay, better to say spring. So hopefully there will be that will be a useful, if it goes the right way, it will be a useful tool in the armoury to seek justice on this mis-selling.
Yeah, the position has unfortunately changed, and not changed for the better. When Sajid Javid initially launched the white paper on fixing the broken housing market back in 2017, he made a commitment that the government would look to bring forward early legislation to address existing onerous lease terms. And unfortunately, particularly on leasehold houses, and I think the commitment was at one point before the summer, and I think that was before the summer of 2018. That did not happen. Unfortunately, the Law Commission was not tasked with looking at it as an issue. The Law Commission had, back in 2017, proposed 10 separate projects on leasehold reform that it felt it should look at. It was given 3 of those projects to undertake, and they are beginning to report in the spring. One on common hold, one on right to manage, and the other on enfranchisement. There is a 4th project that they were given just before the election to look at the forfeiture issue. But that means there are 6 further projects that the Law Commission have said to the government they would like to review. And until all 6 of those projects are looked at, you know, we still have some major pieces of leasehold legislation which are in need of fundamental reform.
Great, thank you. And back to Rebecca, I think May have already answered this, but do you think it's a realistic proposition for the government to legislate for the removal of onerous lease terms for existing leases, i.e. retrospectively?
Difficult. You also have a problem. I mean, one of the big things that's been raised in relation to the ground rents, for example, the freeholder landlords, Article 1, First Protocol rights, which is right not to be deprived of property, and if you're not going to be paying compensation, you're without question you'll be facing a challenge. I mean, the problem is that the government legislating to that effect could, I mean, they have to, because of the Human Rights Act, they have to declare whether they consider it's compatible or not, so they have to go through that whole process. I mean, it's something which is raised by the Law Commission in the recent paper on the valuation and enfranchisement.
Thank you. And I think we may have touched on the next question as well, but I'll ask it anyway. How effective is the right to manage or collective enfranchisement at overcoming some of the issues leaseholders face?
Well, it's helped, but it's not helped enough, and it's clever lawyers have run rings round it, and the Law Commission is bringing out a report on right to manage to dust it down and kind of reform it and make it more effective. But it has given leaseholders the right to manage their sites in numerous cases. I think there's about 5,000 right to manage companies, and there's resident management companies which were in the lease anyway, which are sort of self-managing. So there are a considerable number of self-managing sites. Right to Managers has done some good things. One of the areas we're involved in is retirement housing. Something has gone very badly wrong in a retirement site when a number of people in their mid-80s to mid-90s decide they want to opt for right to manage with all the rigmarole that involves. But it has happened, and it has been because the right to manage exists on the statute book that they have been able to kick out the management imposed by their often offshore freeholder and manage their own sites happily. So it's a very good thing, but it needs improving.
Thank you. Thank you, Chair.
Can I make one other, on the enfranchisement point, we have something that I think is utterly ridiculous at the moment. The government's ACM remediation fund, £200 million of taxpayers' money to be paid into the private sector. The way the system is working is that the leaseholders have to sign a form to obtain the state aid. That aid isn't actually paid to them, it's paid to the offshore freeholder. Why on earth is the government giving £200 million to offshore freeholders rather than saying, well, this is an ideal opportunity to enfranchise these sites?
Well, this is what I was mentioning with the North Point site in Bromley. 57 flats there, £4 million cladding bill, annual income £7,000 in ground rents. The freeholder there has minimal interest in that site. As it happens, this is the Chengit's Family Trust, which has a debenture to Ross Say Life, a Goldman Sachs founded pension investor. So, in fact, that ground rent income goes immediately to Ross Say Life. So, Vincent Chengit's, who is the ultimate beneficiary of the Chengit's Family Trust, probably gets 2 subletting fees from North Point every year, which is £130 each. So it's absolutely minimal, his involvement in that site. How on earth the government can use the service charge regime to sort out these cladding sites absolutely astonishes us.
Really good point, and we do need to be following up on whether that money is being well spent as well. I think it's a very good question. I actually wanted to ask a question about the number of right to manage properties, and I think, Sebastian, you answered that just now. You said there were 5,000 resident management companies.
Sorry, no, right to manage companies.
So, right, yeah, so they've taken up the right to manage, and now they are resident bodies that manage. Is that right, or is that 5,000 properties?
No, it's 5,000 right to manage companies, and it's very easy to quantify because a company's house, the company name has to have RTM in it. So it's...
I can look that up myself in that case. Do you know how many properties that actually covers, though? Or is that, can you guess at that? What's the size of a block generally?
Very difficult. I mean, look, when we looked at the numbers in 2014, it sort of looked as if it might be about 20 to 30 properties per right to manage company. There are one or two very large ones, but the vast majority look as if they're quite small.
Okay, so we can make some estimates.
There would be more resident management companies which were incorporated in the lease from the start. So, for example, Neo Bankside, which is just around the corner from here, has a residence management company that was in the lease. You know.
Yeah, in, like the law, isn't it? That one written. So yes, but these are the ones that have used right to manage legislation is what we're sort of asking about. Are you aware? And this is quite hypothetical, but some blocks are not that large, and we are aware of some leaseholders being landlords, as it were. They buy the lease and then they rent out the properties, and people own multiple properties, often distributed around. But some landlords own more than one property, several properties within a block. Are you aware of any landlords using this legislation to gain the right to manage from a leaseholder, or is that not something landlords can do? Does it have to be resident leaseholders?
No, it doesn't have to be residents. You just need to own. There are inevitably some sort of democracy issues where one individual or a small group of individual organisations own a large number of properties within the site. Yeah. And you will get that within the social sector as well.
Yeah,
it's very
definitely
unlikely
seen it with
that the social landlord will become a minority interest.
Is your question really about where these self-managing sites fall down and games are played amongst the leaseholders? Because is that where you're going? Because
somewhat, but also from a business point of view, if you're a landlord who owns 8 out of 10 flats in a block, the incentive to you to then get right to manage for that block and gain the freehold in terms of your own investment is very, very high. Yeah. And so I'm asking whether this is a thing and whether we need to guard against it, and whether we need to think about guarding against that in legislation. If we're trying to empower residents, then that's not the same thing.
There's certainly protections that are needed, and there aren't really any there at the moment, and there aren't any that are currently sitting within the common hold environment if we move to that regime. And hopefully one of the benefits of moving to common hold is we move away from the idea that we have to keep going to the courts over every single issue, and there should be some means, and there is in other countries, of helping to encourage a democratic approach and to ensure that the majority don't oppress the minority.
Sebastian, did you want to say, you were about to say something about democracy?
I do want to acknowledge that on the forest floor of Leasehold, games are played even by not the non-typical commercial operators. And in the sort of block that you were suggesting, if I was thinking of buying a flat in a block of 10, say, and a landlord owned 8 of them, I would know that he was going to call the shots throughout, and I would be very wary as a result. I'm aware of a site in North London where it was only 8 flats and it was in franchise, but 2 families had got together and were re-enfranchising the block of flats and wanted to put 2 penthouses, £3 million each, on the roof of this block of flats and compensate the the non-participating members with, I think it was £5,000 each. It's going through the courts at the moment. So yes, games are played, but and indeed, knowing Italy and France as I do, of places which have common hold system, flat owners do squabble amongst themselves, certainly. What's unique about the English system, or the system of England and Wales, is that you have it industrialised. You have a sort of commercial leasehold sector where people are sort of, this is a wonderful, the leasehold system is a great way of hitching a ride on the UK residential property boom, and to be empowered. So you have this speculation in freeholds, which is quite alien to other jurisdictions. And so you have absurdities in England, like over the cladding site, how do I get in touch with my neighbours? They're all based in Singapore or wherever, all investors all over the place. To me, that strikes me as astonishing, because in every block of flats where I've owned flats in Italy and France, the list of owners is on a board in the foyer. And not only is there a list of the owners and their addresses and how to contact them, but whether they paid up. Everybody knows what's going on in a block of flats. Why on earth the English ones are so secret is really, well, I was going to say it's a mystery, but it isn't a mystery, because keeping leaseholders divided and disunited is absolutely in the commercial interests of the freehold sector.
Okay, thank you. So there are problems, but they're problems we'd rather have, is
Yes.
kind of what you're saying. Thank you.
Bring you down, Sir William.
Yes. We just on that, we don't yet have, do we, a register of landlords, the point you're making?
No.
Scotland does, but we don't.
And
England
when they're
doesn't.
offshore, who on earth are they?
Sorry?
And when they're offshore, who on earth are they?
Yeah.
And some of these offshore entities own cladding sites and have got to make very difficult decisions. Yet we have absolutely no idea who they are.
It's absolutely ridiculous, and so many, so many of us have argued about that, but still we haven't got it.
It's
I
an
just
issue
wanted to
that
ask-
is being
Sorry, my voice
the
came.
problems that caused is being crystallised by the cladding crisis again, and the National Fire Chiefs Council Chair has made clear that trying to contact entities that are based in Jersey or the Cayman Islands to find out who or what they are or what they're doing with buildings has been, we are aware that all the local authorities are currently being tasked with collecting data on the blocks that they have in their boroughs, and we have seen letters from one of the more central London boroughs where they are simply writing to the address with a letter that says, "Dear property manager," in the hope that somehow whoever's managing that building is going to pick that letter up and then write back to the local authority to tell them what's at that building, whether it's got cladding, whether there are building safety issues. And it's not a very sophisticated approach. We sort of need to know about all of these buildings.
That's very interesting. Something we should take up. Just while moving on now, it's been a bit touched on. I just start with you, Martin, and then we might ask the others. Some flats have a share of the freehold, and I want to know from you, what does that mean practically, and how does it differ from common hold?
Okay, right. Well, that's effectively what we have at our development, and in many ways, if you've got a leasehold block and there is share of the whole, share of the freehold, it is quite similar to common hold in a number of aspects, but you are still stuck with landlord and tenant legislation. I am still stuck that if we have a delinquent leaseholder who doesn't pay their service charge, I don't really have much option but to notify them that they're in breach of the lease. And if I don't follow the procedures for someone who's breaching the terms of the lease, then I might lose some of my rights to take action against them. So you lose most of the problems with leasehold law, but not all of them. And what you don't gain, which you do gain in a common hold world, is that almost all leases in the private sector prevent the landlord from improving the building. And that includes
from what?
from improving the building.
Right.
Okay, and that will include those sites where the leaseholders own the share of the freehold. So we live in this slightly, I don't know, ridiculous world, let's call it, where, you know, all the blocks in London are not meant to be improved in perpetuity. Now, in a common hold world, what you quite logically do is sit there and say, well, actually, you know, we want to put some solar panels on the roof because that's beneficial to the block, or we want to improve the environmental systems that we've got here, and we wanted to reduce our energy bills. And you just do it as a common hold. You make an agreement and go, that's what we want to do, done. Right? We have had to, at our site, abandon a plan to put in solar panels for the third time. Not because anyone on the site objects, but because all of the systems out there assume that leasehold is so complicated, you can't put solar panels on blocks of flats very easily, because someone might argue that that's an improvement.
That's so shocking. Do other, Sebastian and Rebecca, do you want to add anything to that?
No, I think that detail was compelling, really. I mean,
Sorry, can you speak up?
Sorry, I think that evidence is compelling. You know, if you make an enhancement to a building, you're in breach of lease. So I guess leave it there.
Just going back to Martin, do you see in the future that common hold is a viable alternative? You obviously do, actually, to lease.
Yeah, I mean, when we started doing our work, you know, back in 2008, 9, 10, the whole of the system was telling us that we were wrong, and that the leasehold system was working well. There weren't any problems, you know, and that's what your predecessors concluded. The government felt in 2012 there wasn't any need to reform the legislation. We've helped manage to convince the system there are fundamental problems. When we first started looking at common hold in 2014, we managed to arrange debate in Parliament. I was completely agnostic about the issue. We had the government officials telling us that the market simply did not want common hold. They tried it, the market didn't want it, they were told there's nothing to do. Everyone else who came into the meeting said, no, the problem was the legislation was flawed. There are too many incentives to build leasehold. And everyone else somehow does manage to build common hold. And we've had various people coming over from Australia, and they've said this argument about you can't build common hold on very complex and very large site is rubbish. The largest strata title site in Sydney being developed at the moment is a 14-hectare site. It has a huge number of residential, commercial elements to it, and it will take years and years to develop. They have no problems. And I think over here, if we can get the legislation right, then logically common hold will be a route that people will go down very quickly.
Sebastian and Rebecca, do you agree with that?
Yes, absolutely.
No, it's what I was saying earlier about the existing common hold legislation probably is not really fit for purpose, and that the problem I identified, I don't know if it's too much, but the problem I identified was this, you know, issue about big, huge mixed-use developments. So that's why it needs to be looked at again.
I think that, you know, when it was common hold came in, it was envisaged that there would be a sunset clause, and that beyond a certain date, developers would have to build a common hold, and it was dropped. And of course, without compulsion, developers were making so much money playing the leasehold game that they're not going to do it. But as somebody who has direct experience of common hold, because I've owned flats in France and in Italy, I can tell you that it's, you know, it is a very simple system. I mean, it is a huge pain in the neck having to attend condominium meetings, but the only thing worse than managing a block of flats is not managing a block of flats and somebody else doing it, especially when they have all the ample opportunities to turn you over as they do in England and Wales.
Right, but what about, I mean, don't you discuss a lot of the issues to do with leaseholding. Don't you have some of those issues too if you're common hold? I mean, what, for instance, happens if you're in a block with Grenfell type cladding?
Yes.
Then what about, having to pay those charges? when you actually have had no responsibility.
Yeah, I think you're
Putting it in and,
you would
you know,
be in a much, much better position. Your position as a leaseholder is you have no real right to take any action against anyone for the fact they've put cladding on your building. It's very difficult to force someone to change. There are one or two potential actions happening, but it's so far nothing. If you were living in a common hold environment, you would simply turn around and say, right, we need to raise some money if we think we're able to sue someone for the fact they put this cladding on our block. At the moment, in what we have over here, is everyone accepts no leaseholder is responsible for the fact that they put cladding on the outside of their building. Many people bought flats which the landlord actually knew had cladding on and didn't even tell them. So we've had people bought flats in 2018 and they are in there for 3 months and they suddenly discover that they've actually bought something that's worthless. It doesn't solve it if you're living in a common hold world. There's no magic, sort of money going to arrive, but at least there's been a more effective means by which fault can be established. And in Australia, they have had many more developers agreed to remediate the buildings, and the government has been able to get themselves into a much more effective position in deciding what to do on those buildings which won't be remediated by the developer. And that's been a mixture of, in some instances, the government has paid to remediate, and in some instances, the government has made loans available. Because another problem we have here is the moment you've discovered you live in a cladding block, your properties effectively become worthless, so you can't borrow the money to fix the cladding on your block. Whereas if you were to live in a common hold world, then you might be able to take a very different approach, and the site would be able to perhaps borrow money from the government or somewhere else to help fix the building.
I mean, a closer example is Scotland, which is having exactly the same problems of having to remediate its buildings as well. But there is a direct contractual connection between the owners of real owners of flats in Scotland and the developers who put it up and the regulators who approved it. Whereas in this country, as a leaseholder, you would have to persuade your freeholder to take legal action against the regulators or against the developers because you are only a tenant. It's not your building.
Okay, thank you all very much.
Yeah, so you've referred to the fact that the Law Society is doing these 6 projects, not just looking into the idea of whether or not moving over to common hold might be a good thing. But I mean, there does seem to be this sort of lack of take-up, really, as an alternative. What do you think are the main barriers to that sort of increase in take-up?
If you're a developer, you'd be absolutely mad to go to opt for common hold, given that you could make much more money out of playing the leasehold system. That's the most obvious answer. I mean,
so you're saying the barrier is really with the freeholders being willing to grant the common holds?
No, it's with the developers.
Developers.
Because with the developer, you sell the flats for what you can get for them, and then the cherry on the cake is selling the freehold to some speculator in ground rents. So an example there's actually a rather successful and sweet example of a common hold site in Pickering in North Yorkshire. It was built common hold by a New Zealand architect developer, probably because he didn't know any different, and he built it as common hold. He went bust in 2008, like so many developers did, but it's now a very successful common hold site. But it's an anomaly. Why he could have built that same site and sold the freehold for £250,000.
So, for example, when the mayor is granting the planning permissions, which comes back to something that Assembly Member Berry was talking about earlier on, that if it was a requirement that the developers had to sell anything on as a common hold, that would be something that could be included as part of the planning arrangements, as a condition, perhaps. then that might be one way of...
It could, in theory, it couldn't yet, because obviously there are problems with the legislation. The government's accepted there are two parts to changing our tenure, and there's the sort of carrot and the stick. And the sort of stick for the developers is the government has made very clear that we are moving to a zero ground rent system going forward. So if the developer can't sell on the ground rent rights, that is the only legitimate income stream that the freehold investor has. There are other additional income streams that they may get out of, providing insurance for the building or commissions out of property management. But those aren't income streams that you can go to the bank and borrow money against.
So do you think there is still a requirement to continue with leasehold? Obviously there are some developments that are more complicated than others, and we've just referred to the complexities of your backyard scheme, if I might call it that, Martin. But for example, where you've got shelter developments or something that includes commercial in there, is there, or could we just flip everybody over to common hold instead of leasehold?
I think it will take time, and what's been very clear for everyone who's spoken about it is,
well, let's say for new, we could move everyone onto that for new, do you think?
For new, yeah. And what will happen if we follow other countries is you gradually transition existing stock. Nobody is going to convert a current leasehold site to a common hold site unless they think it's going to add value to their properties. No mortgage company is going to allow it to happen unless it thinks it's going to add value to the properties. And that will take time, and it will probably, 4 or 5 years after the legislation comes forward and we move over the new build stock, then you will start to see existing stock transition.
So, sorry,
one area where you might see this is in the retirement sector.
Yes.
You've got a retirement trade body called ARCO, the Association of Retirement Community Operators, which runs the more intensively managed retirement sites. And they've set
so, for example, McCarthy and Stone?
No, not McCarthy and
Not
Stone.
McCarthy.
That is a sort of volume house builder business model. It would be people like Audley, the Extra Care Charitable Trust, organisations of that's a retirement living. These retirement villages, that sort of thing. They provide a kind of community and manage it. So these operators have said we don't need ground rents at all, as opposed to McCarthy and Stone and Churchill saying that they're essential for the retirement house building business model. They don't need it because they manage these sites permanently for the long term, and they're managing quite complicated things. They might be providing some care, they'd be providing sort of restaurants and other facilities of the site. So the management of that is really crucial. And then I'm moving, considering a license to occupy rather than leasehold. But leasehold in that sort of circumstance is not essential, but it does work because you've got a freeholder who's actually is the management company. This is the business that you're buying into. This is the asset really. Whereas they sort of kick out some flats, flog them for what you can get for them, then sell the freehold to whoever wants to have a punt on some freehold is an entirely different business model.
And so, if we were going to assume that as many as possible knew, and then we were going to sort of transition everybody else onto common hold, how would that work out in something like, for example, where we've got shared owners who might be paying rent on a quarter of their domicile, and then they've got a shared ownership on a leasehold basis for the other 75% or some variation
It's one
of
of
that?
the specific issues that the Law Commission is looking at. And it's very clear in other countries. Obviously, you do have common hold working in both the shared ownership part of the market and in the commercial part of the market. The question, the philosophical question that's sort of been asked is do you transition the system in 1 or 2 jumps? Because it gets a bit more complicated than just in private sector.
Mm. And what about in the case of community land trusts?
Yes, well,
Is the Law Commission looking at that as well?
We actively encourage them to sort of push common holds, particularly at that group. They were cautious in a number of the consultations because, rather oddly, some of them argued that they used the ground rent for community projects, and it seemed to be an argument that faced in both directions. They felt we should have ground rents limited to a very small amount, but they should have the right to keep those ground rents. And we said to them, well, if you want to do community projects in the common hold world, you just go, we want to do a community project, and if everyone agrees or the majority agree, then that's it, you do the community project.
So apart from the planning element that I just referred to, and that we've been saying might be a way for the Mayor to encourage, in inverted commas, developers to include common hold rather than other forms, do you think there's anything else that the Mayor or the London boroughs could do to encourage common hold to become more common rather than leasehold?
We won't know until the legislative reforms come through. I mean, but if they get the shared ownership element right, then there seems absolutely no reason why the Mayor can't say, well, if you're using my money, you will develop common hold. Thank you.
Yeah, that seems like a very obvious thing. The Mayor asks for other things when he's involved in a development in that way, but obviously the Mayor also has some involvement through the planning process in schemes where there's not necessarily funding from City Hall if it's taller than a certain height or if there's more than a certain number of units. So would you suggest beyond just, well, I'm putting some money in so I want this, that it could be used more widely, couldn't it?
Yeah, absolutely.
Yeah, okay. We've referred to the government looking at this. We've talked about the Law Commission having a look at these sort of 6 different areas. Do you have any sort of idea as to, this is probably going to be how long is a piece of elastic, but when we might actually see any response from all of these investigations into these things, and when we might actually see any actual practical change coming through?
Yeah, there's been some criticism. We've had 8 consultations now without...
Just 8?
Just the 8. And obviously the Brexit issues caused many delays. We understand that there is a draft bill to be produced in the near future that will address the first of the sets of issues to be looked at. How long it takes to look at the rest, who knows?
So a draft bill coming soon.
Some spring.
Spring. Well, it's spring now, isn't it? I can tell.
Yeah, government spring lasts a lot longer than other
spring
springs.
starts in June. It continues until June, right? So it could pop up at any point between now and June.
One could add that it is a bit
sure.
disappointing that the government has sort of announced, I think, 4 times that it's going to reduce, set new ground rents at 0 and ban leasehold houses. Well, there's no reason really to wait for any of these reports from the Law Commission. It just needs to do that. Setting new ground rents to 0 in itself would be such a gear shift in the leasehold sector. It opens the question to common hold that it would be very welcome indeed for them just do what they said they would do. I think it was back in 2017, the end of 2007, Easter 2018, that they would do this. So can they please get on with it?
You don't feel that we need another 8 consultations
I'm
about
afraid
this
I don't,
matter?
no.
Before we actually make a decision. Well, given how long it's taken us to make a decision on HS2, and I'm reliably informed by all the media that the decision is going to be made today, and it's funny because I thought we'd made it at least 8 times previously. I'm not going to hold my breath, but it would be good to know that we can proceed without another 8 consultations. Thank you, Chair.
Thank you. Okay, moving on to the last set of questions. If I can bring you in, Mr. Berry, or overview of reform work.
Can I just ask one more question relating to the last section?
Sorry.
We were to have a representative from Southwark Council here to ask about council works, but this is, I think the high cost of repairs is not just confined to council leaseholders, I don't think. Obviously, I'm a local councillor. I experience a lot of issues around major works, and I wanted to ask some questions today. But I wondered if, Martin, you might be able to comment on this. we've got some evidence, some small evidence from my local area that potentially allowing residents themselves to commission major works on their own blocks has saved money compared to the big contracts that the council lets out. And you can sort of see that if a freeholder in the private sector is commissioning works, they're under no... I mean, the council is trying to save public money, so they should be getting good value. But a freeholder is not compelled to do that either. So do you have any evidence from your work that leaseholders who are in control of their major works and repairs get better value or keep a closer eye on costs than potentially their landlords
Yeah,
do?
there was a TMO that was speaking at one of the Southwark events who pointed out that they were getting some considerable cost savings. The difficulty for the large authorities is that they are large, they're letting some huge contracts, and there seems to have been a fundamental misunderstanding about how contracts should be let in the social sector. The argument has been that they ought to be using call-off contracts, which go on for many, many years. And the argument used to be that they had to do this on 3 grounds. One was as part of the European procurement rules. The other was to demonstrate to government that they were getting best value for money. And the third argument was because they were meant to follow something called the Egan Principles, which was a report produced, came out of a report produced for the government in the late 1990s by Sir John Egan, who was the man credited with saving Jaguar. And when government started looking at major works procurements a number of years ago, nobody could ever explain to me why the social sector worked like it is. And so we asked various bits of MHCLG, and eventually somebody came back to us and said, well, we don't think there's anything in the value for money statements that require these large contracts. And then somebody else came back and said, well, the European procurement rules, we don't think that applies to most RSLs other than local authorities. Because there was this shenanigans about moving everything off the public books some years ago. So the argument was, well, if it's no longer on the public books, then the European procurement rules don't apply anymore. And then I thought, well, this John Egan, we ought to ask him. So he's still alive. We got him down to a meeting in Parliament the other year, and he was quite rude about the idea that somebody had taken his proposals and turned it into the way that they run procurement in the social sector. And he basically said, I designed a set of principles for new build. It was never, ever intended to use what I was recommending for ongoing maintenance. And he said, his view was, unless you can demonstrate not only value for money at the start of the project, but on ongoing improvement in value for money throughout the whole length of the project, you shouldn't be doing it.
Interesting. Okay, well, obviously we need to write to Southwark to get the answers to the questions that we might have got.
Before you ask your next set of questions, can I take this opportunity to welcome people from the Christchurch Primary School from Redbridge? This is the meeting of the Housing Committee, and we are talking about a topic, which is of great importance to Londoners, about flats and what are called leasehold flats. Not exactly the most riveting discussion, except, but you're welcome.
Well, I think we should probably ask them, who lives in a house? Yeah, you all live in houses. So it's an important discussion for you, isn't it? The same as for us.
Sean, can I ask
Thank you. Yes, apologies. I was interested in the European contracting process and didn't welcome young people. Anyway, I am about to ask some more questions about legislation and how likely it is to come through. I think Assembly Member Cooper shares my scepticism that we might see anything soon. Certainly the Queen's speech was briefed ahead of time that the government would be taking forwards and government will and all of that, and then there was no actual bill announced. There's no mention in the Queen said of the word leasehold at all. So, yeah, how likely do you think it's going to be that we're going to see anything? It was 2 years between the last Queen's speech.
It was in the supporting documentation, so the Queen didn't actually say it, but if you look at the bigger document...
That's what I'm referring to, yes.
Yeah.
Yeah, so how likely do you think it is that we're going to see anything, given we might not see another Queen's speech for 2 years like we did last time?
I don't think we have any influence on how it would be just speculation. I mean, what is very clear is that there is now a much better understanding within the system, and there are many, many more MPs who understand why there are problems that need to be fixed. And that was one of the reasons why the all-party parliamentary group on leasehold reform was set up in 2016, and it's played a very active role in helping push the government. And it's been very surprising that it seems to be an utterly cross-party issue. There are no particular disagreements between the MPs from any of the parties, and we've even had an SNP join. MP joined recently, which, given they don't have leasehold in Scotland, was quite odd. But they were interested because of cladding.
Okay, and obviously a lot of the MPs changed. The MPs are different now. Are you aware of any campaigns to ask incoming MPs to commit to making this a priority?
We at the end of last Parliament, we had 177 MPs in the group. That's dropped to 136 after the election. We're now back up to 157, and as the new MPs settle in, I'm sure we'll get back to 177 quite quickly.
Yeah, that's quite a big increase already, given how full postbags must be.
Yeah. I mean, it's this was the first election where leasehold actually sort of raised its head above the parapet, such that candidates were talking about it. Historically, it's been an issue that's been too complicated and too dull, to be honest, to sort of raise on the doorstep. But particularly with all the issues that we've had in the north west and northeast with leasehold houses, it's now become something that a lot of new MPs are very interested in.
Perhaps a nice slogan like "Get Common Hold Done" might work.
Making me sad.
Couldn't comment.
There's quite considerable
Nice
interest.
and short, isn't it?
Yeah. Sebastian, I think you wanted to come
Sorry,
in
just
on
to say, we're very heartened by the considerable interest in Parliament in this. I mean, the Community Select Committee, chaired by Clive Betts, came up with an excellent report last year, and and the Conservative members of that also signed up to the report, which was excellent, so there was no minority in that. And although they had some doubts and very tough questioning about some of the points that leaseholders were making, or we were making, but it was it's an extremely good document to have, and the interest from that select committee on this issue continues. And of course, it's worth mentioning that tomorrow Hilary Benn has a Westminster Hall debate on cladding, which will be very well attended. So the cladding issue has now brought in another layer of interest, should we say, to this sector. So, although we're disappointed by the government in action, and if the rumours are true, we're going to have another different communities secretary, which would be so we start all over again. There is a great that probably doesn't reflect the interest that's there is in the Commons.
So, Rebecca, presumably the government's slightly waiting for the Law Commission to finish its work.
I think it's slightly waiting. I think they will be waiting.
Yes. Is the cladding issue going to put off any conclusion? Is that creating wrinkles potentially that might, in your view?
That's not. I don't. They're going to be waiting for the Law Commission related to that. And I mean that's what to do with government policy. I'm not. That's to do with government policy. I'm not really here to comment on policy as such.
Fair enough. Yeah, no, it's just that might be.
I mean, I think there is something to bear in mind, and it is this that over a number of decades, what we've had is successive governments tinkering away at leasehold, and as and when things have happened, you know, we apply a sticking plaster. And I think there is a school of thought which is actually would be quite nice to just, I mean, this is partly to do with common hall, but just to scrap the whole lot and just start all over again. The difficulty is you can't actually necessarily do that when we've had this system in place for so long. So it's not simply a situation of simply just getting rid of things and think, oh, tomorrow everything is going to be common hold. It's far more complex than that. But you know, for example, it's suggesting that, well, actually, was anything really made of it in the Queen's speech? Is there anything going to happen? There is a programme where actually they're kind of trying to look at this as a whole, because we've seen what the problems have been caused historically by just tinkering away.
So it's better to do it take
I
slightly
think
longer
that they
to
are,
do
and
it
that's
well.
what they do.
Yeah.
That's there are various. That's why they're taking all these stages while we're waiting for these various law. People are waiting for these various law commission reports.
Excellent. Chair, do you have any other assembly members waiting, or should we? I mean, the final question I've got is there anything else you'd like to mention? Effectively, yeah. So, is there anything else that we haven't raised here? Any other aspect of changing practice that you think is essential that we haven't asked you about yet?
Yeah. Cladding. We ran a cladding meeting for leaseholders here last week. We had 144 leaseholders turn up. The Fire Chief Commission also spoke. Unfortunately, there was no GLA official willing to speak. There was no government official willing to speak. The people living in cladding blocks are in an awful mess. We've been trying to help for 2.5 years. Unfortunately, the Mayor wrote to the Secretary of State in December and effectively said he doesn't think the GLA should do anything to help cladding leaseholders. And I think that's disgraceful.
Is there minutes of that meeting last week, do you know?
On the website.
Well, there are reports on the website at the Leasehold Knowledge Partnership website. Formal minutes, no, but reports of what the speakers said. I mean, it was, as you heard, it was a very well attended meeting, and Roy Wiltshire, as the senior fire officer, spoke at it. Hilary Benn spoke at it. Professor Susan Bright, Professor of Law at Oxford, spoke at it. So it was a formidable meeting, really. And we have another one scheduled for May the 12th.
Which
Here.
you're welcome to come to.
Thank you.
Can I ask, did you invite?
We did. We invited the Mayor. We invited Tom just as he was transitioning across, so we understand why Tom might not be able to. And GLA officials were invited to come and speak. GLA officials did attend, but they didn't speak, unfortunately.
A committee member would have been a good person to go.
I don't think we were invited.
Yeah, no, but
We weren't invited.
if Tom was invited and then he changed jobs, that might explain the issue.
We'd invited the two deputy mayors, so Fiona was also invited, but Fiona had told us very early on that she had another appointment that so she couldn't attend.
So Tom was invited with his deputy mayor hat on, not as the...
Yeah, not as committee.
Not
Yeah,
as
so,
member.
but he was just transitioning, so
Yeah.
we knew that there was...
Well, I don't think anyone from the housing committee was invited, I think
No.
is what we're saying.
We will make sure we will invite you
That's what it is.
next.
Thank you. Fine. Can I thank our guests for all your contributions? We have a few more formal items on the agenda we need to discuss that you're welcome to stay for. Shouldn't take too long. Can I ask the committee to note the reporter's background to putting questions to the invited guests on leasehold and service charges and the subsequent discussion?
Noted.
Thank you. And can I also ask the committee to agree to delegate authority to me as chair in consultation with party group lead members to agree any outputs from the discussion? Thank you. Item 5, response to Housing Committee report, Living in Limbo, London's temporary accommodation crisis. Can I ask the committee to note the Mayor's response?
Noted.
Thank you. Item 6, Housing Committee work programme. Can I ask the committee to note the Housing Committee work programme? Thank you. And the next meeting of the committee is scheduled to take place in the form of a site visit at a time and a venue to be confirmed. And as I have no other urgent business, I close the meeting. Thank you.